There was no error here. I, as the responsible presiding officer, was making sure that because Mr. Tefo withdrew unceremoniously, even derobing in court and leaving without saying anything, I was making sure that the right of legal representation of accused number 1 to 4 stays protected. And if I did so and you were poised to come back as you did now, we cannot come back and say there was an error. We can only come back and say, I am here, let us proceed. I suspect I wouldn't even have raised the matter of you staying away without saying anything. You are an officer of the court, Mr. Tovani, for God's sake. And you know what is the right thing to be done about absenting oneself from court or attendance or whatever. Even if you need to step out, you know what should be done. That is exactly what you did not do. And all I'm saying now, I'm saying, let us not talk of an error. Let us talk of the fact that you are back, to which I have no qualms, and that we are proceeding.
As the court pleases, my instructions from the clients are that I proceed to deal with the matter.
That is very welcome, very, very welcome. It sort of circumvents other processes that would have had to happen before we proceed. In your absence, we even mooted the issue of availing transcription, because you'll remember that we took a decision back that all proceedings there will be transcription for all proceedings on a daily basis. We would have had to make available those transcriptions for whoever would have had to take over after Mr. Tefo.
Furthermore, Your Worship, my Lord, I did communicate with my colleague from the state that we intend to apply for bail for accused number 2. And it will be better if we arranged with them a date before the 5th of September, so that we cannot interrupt the trial and deal with the bail and finalize it.
The admittance to bail is a right available subject to the law. It is addressed through case law. It is addressed through the Criminal Procedure Act. And there is nothing, there's nothing untoward about it. It's up to you and your client to see how to stage. And in this division, and I think in South Africa and even other jurisdictions in other countries, bail applications are treated as urgent.
I agree with the court.
And it is not dependent upon the whims of the presiding officer or whoever, or the registrar or the DJP or the JP. It is an application that must be made, and once made, or once indication is made that there is a need for an application for admittance to bail, the agency kicks in, and we have to find time. We have to find time. We have to gather because of past experiences. Let me mention it now. We may even have to go and approach, or the three of you may have to go and approach the leadership of this division for purposes of placement, because I think it would be unfair to say it to you, but for purposes of public knowledge, we should not pretend this is the only case in the Republic of South Africa. When this case is not here, there are other people.
As a court
That is why from time to time, when the need arises, we notify and we say, let us meet for this and that purposes. And of late, where we cannot meet physically for that, we even arrange to meet virtually for that. But all I'm saying is that application for bail is a right available at the disposal of everyone who needs to apply. And I need not outline to you. If it was your clients, I would outline what should happen, the ABC of it. So you should go ahead. If that be your instruction, go ahead and see what you need to do about that kind of an application. I think I don't know if, well, from here I can't see if my secretary is here. But I will inform him if he's not here, that there is that eventuality. In this case, because of the public interest there is, where we would have been saying ordinarily there is agency, I would say with emphasis there is agency. Because as you know, the denial or granting of bail impacts on many other people and on many other processes. So that is my attitude.
Thank you, my Lord. My last submission is that I request that when we adjourn, the prison officials allows me 30 minutes to take instructions with regard to the bail on only accused number 2. As court pleases.
Yeah, as you know, my attitude is you should be able to consult all the time when you have a reasonable request to do so. When I asked my secretary this morning, he told me that the delay is because you need to consult, and I was a bit surprised because in my book it was always possible to do it this way, for us to come and sit and postpone this matter, and you do as you are doing now, and correctly so and rightly so. You request that you be given time to consult, and as I sit here, I don't think I even need to issue an order. It's in the morning now. Accused persons can only be taken wherever, home or to prison, later in the day. So it is my imagination that when you want to consult, it will be touch and go. If it doesn't pan out that way, I will advise that your 2 colleagues be informed immediately, and that I be made to know immediately that you are confronted with hurdles in your strive to consult your clients.
As a court pleases.
Mr. Baloyi, you said you want. Before we do that, I don't know if Advocate Nshololo has anything to say as at now.
No, my Lord, I've got nothing.
As a court, please, my Lord, we can then adjourn the matter to the 5th of September for the continuation of the trial. I understand from our learned friend that he'll consult after the matter has been adjourned, so it's not necessary for now to adjourn and then to come back. So we can already at this stage adjourn the matter for continuation of the proceedings. All the accusers are in custody. I confirm
Before I do that, I think there's something brief that I need to spell out. And I think it's also, it might be a bit unfair for advocate, for Mr. Tobane. My sense, and a very strong sense, is that we are running an open court. In other words, anybody can attend, anybody can have access to what is happening in court. how should I put it? There are times when I'm getting communication, Mr. Tovane. There are times when I'm getting communication about this case. And I am getting to learn about the communication, sometimes on billboards. You are driving wherever and you see a placard of a particular publication with a heading which informs you about what is next to happen. And if it didn't happen repeatedly, I would still be had to be saying, is that in the same case where I'm involved? Because I'm learning about some development from a billboard, driving somewhere, home or church or wherever, and then you learn about those things. And when that communication arrives, you realize it is, I'm saying it also because you are the instructing attorney, you realize that it is also addressed to you, I mean me. And I don't want to get into that. I think it would not be the opportune time. And you wonder, is the court now a pen pal of the legal representatives, or what is happening? But I don't want to get deeper into that because it might turn out very unfair against you. But I needed for you to hear this because you are the instructing attorney. And so I felt that I should say this. In those communications, there are many issues that we should not get into. Some of them are very interesting, very, very interesting. They are about whether, they are even about one's faith, where you place your faith and so forth. Some of us have a physician. I have a physician, and the matter of my physician is not the problem of anybody. It's even irrelevant here, but because of what is happening, one needs to say it out and loud. I have a physician called Jesus, and he needs no augmentation. But it might not be a story for today. Even before I came here, I consulted my physician. When I leave here, I will consult my physician, but it's nobody's business. And I should also not make my physician anybody's physician. And that physician does not make me better than other people. It makes me better than myself by the day. I needed to say that.
Yes, so, Your Lordship, if I may just say something.
Yes.
If the court can remember, I hear the court talking about physician.
Yes.
If the court remember,
Yes.
the advocate who was appearing in this matter
Yes.
for 124
Yes.
has withdrawn.
Yes.
When he also talks about whatever he's talking about after he withdraw, then it's not the instructions of the attorney. Then it's not part of this matter anymore. Whatever he says, he says out of his mind.
I needed to hear what you are saying.
Thank you.
I needed to hear what you are saying.
nje ukuthi lokho esekushiwo sekuqalile ke wasukuma uadvocate Baloyi echaza ke inhloso yokuthi sihlangane namuhla ukuthi iqala ke lahlehlisiwe nge-12 zika July hlehliselwa ke namuhla ngoba ke uadvocate ke wathatha isinqumo sokuthi ahoxe kodwa ke icala lona ke bese linelanga elahlehliselwa lona ilanga lange-5 zika September nanje ngoba ke yena ke uadvocate for esewahoqa ke ngoba ke kuthiwa ke namuhla kufanele ukuthi inkantolo izozwa noma yazi ke ukuthi ummeli wenu noma abameli benu kuzokwenzekani ke uqhubeka uyaphambili wasesukuma ke uTT Thobane ekuyena ke ummeli wenu eyichazela inkantolo ukuthi cha ukhona ke namuhla kodwa ke futhi ke uzoqhubeka necala kodwa ke wakusho lokho ke ngokuthi ke ayichazele inkantolo ke la kuye kwavela khona ukuthi kube khona ukukhulumisana phakathi kwenkantolo kanye naye ke ukuthi echaza ukuthi kwaba nephutha ngelanga elingaphambili ngelanga lange-12 kathi ke uadvocate for ehoqa la ecaleni ukuthi ke icala limiselwa namuhla ukuthi ke nizothola ummeli omusha noma abameli abasha ila khona ke inkantolo ibisimchazela khona ke ukuthi kwakuyini imbangela yokuthi kwenzeke lokho ngoba wayengekho yena ngaleli langa futhi akukho okwashiwa uyena uadvocate ukuthi yini imbangela ukuthi ke uTT Thobane angabi khona inkantolo yasimchazela futhi ke ukuthi ke yinto ebivamisile ukuthi yenzeke la enkantolo ukuthi uma ngabe efisa yena ke angabi khona engachazelanga umuntu noma omunye ummeli kaMmangalelwa wesihlanu noma uadvocate Baloyi noma inkantolo futhi nangaleli langa ke inkantolo ayizange nje ichazelwe lutho ke kodwa ke lolo daba ke lube selubekwa phansi ngoba inkantolo ithe nje khona nje efisa ukuthi kwazi yona ke ukuzwe ukuthi ukhona futhi uzoqhubeka ke ilokho ke akushilo ukuthi ngempela ke abamangalelo umangalelo oqala ukuya kuyena umangalelo wesine bashilo impela ke nake ukuthi isifiso sabo ukuthi yena ke aqhubeke ummeli wabo wasechaza ke nenhloso abanayo ke yokuthi babe nesicelo sebail abasenzayo basenzela yena ke umangalelo wesibili nala inkantolo ithe khona ke futhi ke bethi bafisa ukuthi lokho bakwenze ngaphambi kwaleli langa leli icala elizothi liqhubeke ngayo ilanga lange-5 zika September inkantolo ithe ayinayo ke inkinga kulokho uyazi ke yena ukuthi yini ekufanele ayenze nekufanele kulandele ukuthi benze ke kona ke lokho nokuthi ke bazoya yena ehambisana nabanye ke ama advocate lana amabili ke noma beye kubona ke abahola inkantolo lena bakhulumisane nabo bezwe ukuthi kuzokwenzekani ke ngalelo langa lelo.
Please rise.
No, abamangalela bodwa hlala phansi.
You have heard what is to happen.
Nikuzwileke ukuthi kuzokwenzekani noma okuzoqhubeka.
Based on what you have heard, this case is postponed with you in custody to the 5th of September 2022 for further hearing.
Njengoba sanizwileke icala lona lehlehliswa ke lihlehliselwa i5 zika September kuwona lonyaka ila lizoqhubeka khona ke ukuthi liqule icala.
But I've been told that there are some amongst you who aspire to apply for bail.
Inkantolo itsheliwe ukuthi bakhona ke kinina abafisayo ukuthi ke benze isicelo sebail.
That is a right available at your disposal. It's a constitutional right.
Ilungelo ke eninalo ke lelo ngokwayo umthetho sisekelo.
Arrangements, I want to imagine that arrangements, unless something changes, arrangements shall start forthwith to find time to entertain such an application sooner rather than later, and most preferably before the 5th of September.
Inkantolo icabanga ke ukuthi kuzoqala ke ukuthi kulungiselelwe ukuthi leso sicelo leso ke ngaphandleni kokuthi ke kukhona ke okuzoshintsha, futhi inkantolo icabanga nomfisa ukuthi lokho kuzokwenziwa ngaphambilini kwaleli langa lange-5 zika September.
Anything else?
None, my lord.
Lastly, Your Lordship, I would like to apologize that if I created the impression that I don't respect the court by staying away while my advocate was here and attending other matters. And I render an apology on that one.
I think I should say here and now, Mr. Tovani, the apologies is accepted. I want to take it as an officer of the court. You indeed didn't mean anything adverse. But also maybe what you are saying, that this case is traveling on a gravel road, and maybe that is causing some of the hiccups that we are having.
That's a point.
I don't know.